taking the time. I guess from here on out, I'll have to watch my language, and I will, now that we're being recorded. It is my pleasure to be here, and I really get a thrill from talking with people who are so interested in promoting well-being in the profession, which has the interest has obviously grown exponentially, including thanks to the hard work that folks like Heidi have been doing, and I applaud all the work that you all are doing as well. So as far as where I'm coming from in this whole idea of well-being is somewhat of a, some people would say it's somewhat cynical. I think it's more pragmatic. I was, before teaching full-time, I was a practitioner for close to a decade at a firm in New York, so please don't hold that against me. And throughout the time I was practicing, and even when I was a law student, there have been lots of calls in bar journals and law review articles and so on, decrying the amount of mental distress and addiction problems that plague the profession. And sometimes there will be some lip service that is broken through, but nothing is ever really done about it. And so what I try to do with my scholarship is try to show law firms why it's in their interest, essentially to give them a carrot and stick for promoting and prioritizing well-being. And that's what I plan on talking about today. So if you bear with me, I have a short PowerPoint, as presenters are wont to do. So I think I might have, can you all hear me okay?
Yes and no.
I think we may be able to hear you now. Maybe
Okay, how about now?
Yes.
Excellent. I moved my mouse. I guess that's all right. So before I get into the large business case, I think it is important, before we look at all these stark statistics, to really focus on an individual level how this affects people. And there are two relatively well-known cases that got some press in recent years. So the first here is Gabriel McConnell. He was a partner at the firm Sidley Austin. He was in their Los Angeles office as a bankruptcy attorney. And while there, he was doing the work of three people and worked so hard on a particular filing that he worked himself to exhaustion. And he refused to go to the hospital because he was afraid that if he did so, it would, quote, be the end of my career. And then on the morning of Sunday, October 14th, 2018, he received an email to go to the office to, quote, put something together. And he drove to his office and took his gun with him and shot himself in the head in the parking lot. He was 42. Shortly after he died, his wife wrote an open letter, which she wrote simply, "Big Law killed my husband." And this is Peter, who was a partner in the Silicon Valley office of the law firm Wilson Sonsini. According to his ex-wife, he lived in a state of heavy stress as he was obsessed with the competition, about his compensation, about the clients, their demands, and his fear of losing them. And eventually he became a drug addict and died in 2015 from a systemic bacterial infection common to IV drug users. He actually died while on a conference call. He was vomiting, unable to sit up, and slipping in and out of consciousness, but he managed to sign into this conference call. And when he died, or after he died, and they had the memorial service, his wife, she recounts in a New York Times article and later a book about Peter's life, death and addiction. She wrote that as he was being eulogized, many of his colleagues were bent over on their phones, reading and tapping out emails. So their friend and colleague was dead, yet they couldn't stop working long enough to listen to what was being said about him. So these are always powerful individual stories that I think are important, for us to keep in mind when we look at these statistics. Essentially, According to the NIH, about 7% of the general population suffers from depression. Studies going back more than 30 years have shown that lawyers suffer from depression about 3 times as much. And many of them experience suicidal ideation. Famous study from Johns Hopkins University in 1990 showed that lawyers have the highest odds ratio among 104 professions for major depressive disorder at nearly 4 times the rate of the general population. And in 2016, the landmark study by Patrick Krill, which helped inform the National Task Force report, study of over 13,000 lawyers, found that the numbers over time have actually gotten worse. About 28% of lawyers screened positive for clinical depression, and nearly 46% self-reported. 19% screened positive for anxiety, and more than 60% self-reported, and so on. And a more recent study, which I'll get to in a few minutes, shows that the numbers are the same, if not worse, than they were pre-pandemic. And as a result of Patrick's report and others, the National Task Force issued their report, The Path to Lawyer Wellbeing, which really called to action the profession to take steps to address the public health crisis of addiction and mental distress in the profession. And essentially, there were three action items, or 3 reasons to take action. The first was organizational effectiveness, the second, ethical integrity, and the third, humanitarian concerns. And the task force report is fantastic. I encourage anyone who hasn't to read it, and if you have, read it again. It is vitally important to the health of our profession going forward, to take the lessons from the task force report seriously. But the task force report really only, in stating the reasons why we need to take action, focus on the second and third of these reasons, and don't really talk more about organizational effectiveness. And so that's what I try to take on in my scholarship, to essentially show firms that it is to their benefit, not just the greater good benefit, to actually promote and prioritize well-being. Now, before getting there have been lots of articles and studies about why the profession is in such a state as it is. Initially, it was thought that people are just born that way, that there is a quote unquote lawyer personality, and that something about the profession drives like-minded people who are prone to unhappiness, prone to mental distress, prone to addiction issues, to join this one particular profession. Second, there's law school. And as a teacher of first year course every year, I get to relive the trauma of first year of law school every year. And right now we're midway through the first semester, and I will not inflict any trauma on you all by talking about what 1Ls go through, but there are a lot of systemic issues with the way law school teaches law students and the way law school is run, that contribute to mental distress and addiction issues. But that's another presentation for another time. The third, and what I'll focus on, are aspects about the profession that do cause or exacerbate these issues. And it's widely known that this is the case, so much so that it has been fodder for popular culture.
Jared, we can't hear we can't hear it.
Oh, that's a shame, because it was really fun.
I've seen it. It is.
Okay, so I'll just move on. So yes, but at least I found in teaching, students these days, that having these clips in here at least give me a chance to, fit in drink pauses and the like. So I at least accomplished that part of the mission, if not entertain you all. So why does this happen? What about the profession really brings about these issues? And psychology research shows that there are essentially three psychological needs that people have in order to improve their subjective well-being: feeling autonomous, feeling competent, and feeling connected to others, as well as promoting their own internal values and motivations. And the profession really does a great job at undermining all of those things. So first, the idea of not being autonomous. It primarily arises from the prevalence and reliance upon the billable hour model. So in the early 1980s, few firms had minimum requirements. Today, most firms set them at about 2,000, but many of them expect much more. Now, it stands to reason that billable hours are antithetical to productivity, but they're the standard measure of output. So you're not being rewarded by the quality of your work, more so the quantity, or more cynically, the amount of time it takes you to perform that work. And as a result, we also have to work about 50% more hours to actually hit the billing target. Now, the lack of competence comes in with the low decision latitude, particularly among junior associates. So junior lawyers have very little say over their work, limited interaction with more senior lawyers, and little to no client contact. There's also little to no mentoring, training, or firm citizenship behaviors. Associates feel isolated and is little more than merely billing units. And as far as technology being ubiquitous, we are constantly on call. Rather than feeling unconstrained by having to sit in our office, the flip side of that is we are accessible at any time, which has become even more prevalent in light of the COVID-19 pandemic. As far as the lack of relatedness, the adversarial system, something about that also diminishes our subjective well-being. We're trained to be competitive and aggressive because the goal is to win. And I see this even in law school, where you're not just graded based on your own assessment, but you're graded in comparison to your classmates. Training is fueled by negative emotions, such as issue spotting, finding fault, being overly critical, as opposed to problem solving and consensus building. And practice is seen sometimes as a series of zero-sum disputes that can produce predictable emotional consequences for the lawyer, because we don't really leave those feelings at the door when we're done with our work. And focusing on extrinsic values rather than internal ones, essentially law firms and the profession has become commodified, where the main purpose is making money. Firms are profit-making enterprises. And especially nowadays, lawyers have much more unpaid debt than they did in past years, and are trying to figure out a way to repay that debt. And one thing that law firms are very good at when they see problems, such as attorney attrition or more rumblings about lawyer unhappiness, is they throw money at the problem. In 2019, before the pandemic, but during the height of these calls for changes to the profession, one of the main things that at least the AmLaw 100 firms did was raise their incoming associate salary as a way of saying, we really care about your well-being, here's some money. So why is this essentially happen? This really came about beginning in the 80s, thanks to the American Lawyer, where the American Lawyer magazine rates firms not by the quality of their work or the victories they achieve or the services they provide to their clients, but the gross revenues that they earn, as well as the profits per equity partner. So in 1985, when the AmLaw 100 first came out, revenues were about $7 billion in 2018 money. This is all adjusted. In 2010, once it became the standard for firms' prestige to be the amount of money they bring in, it became $71 billion. And then in 2018, just 8 years later, it became nearly 100 billion. And consequently, the profits per partner also increased exponentially. In 1985, it was $300,000 per partner. In 2010, it was 1.6 million per partner. And in 2018, more than 2.5 million per partner. Now, a lot of law firms follow what I will call the three-legged stool of the Cravath, Swain, and Moore model, which essentially is high leverage, high hourly rates, and high billable hours. requirements. So leverage is the ratio of attorneys to equity partners. So the more partners the more associates you have per partner, the higher the ratio, therefore the more profits per partner. So the idea is you hire many associates with the expectation that few, if any, will make partner. The AmLaw 100 average ratio in 1985 was 1.76. In 2018, it was nearly 3 times that amount. Hourly rates have risen steadily, both before and after the Great Recession of 2008, and evidence has shown that rates have increased even more at a higher rate in the last year due to the pandemic. And billable hour expectations have increased dramatically over the lifespan of the AmLaw 100. Now, this profit-centered model and the way law firms have run really bring about a lot of costs. The first is that there are a lot of monetary costs due to lawyer discipline. Depending on the study you look at, anywhere between 40 to 70% of disciplinary proceedings and malpractice claims involve substance abuse, depression, or both. There's also a lot of costs due to absenteeism. Absenteeism is when people are unavailable. Presenteeism is when you are working inefficiently. Now, there haven't been studies with respect to law firms specifically, but there are many studies in other professions that I think are instructive. And according to studies of many different professions, have found the following. Depression essentially doubles the annual sickness days among employees. Employees with untreated mental illness report losing between 4.3 and 5.5 days of productive work per month. Employees with untreated depression have 3.7 times more unproductive time at work than those without depression. And this creates a lot of indirect costs due to absenteeism and presenteeism, the lost business and the lost productivity. So about $102 billion per year for depression and nearly $180 billion for alcohol abuse. And 71% of employer expenditures on employee mental health issues and 72% of employer expenditures on alcohol abuse are for lost productivity due to presenteeism. Now, this leads not only to the decline in health and well-being, but also diminished cognitive capacity. Lawyers have to operate at a high level, but untreated mental distress and addiction issues decrease cognitive capacity. And kind of a related aspect is the lack of sleep that the law firm model, and the profession model really engenders. Long hours and all-day availability leads to lack of sleep, and sustained lack of sleep leads to cognitive impairment that is equal to legal intoxication and can lead to or exacerbate depression and other mental illness. An additional cost are the replacement costs, as well as the high attrition of lawyers. Firms lose 75% of their associates within 5 years, and about 16% each year. And the early trends, now that we're in, unfortunately, the second year of the COVID-19 pandemic, suggest that there will be a great migration of law firms with greater attrition, especially those that are more senior. So senior associates, junior partners, and of counsel are going to be leaving their firms, if not the profession in general. And a study from 2017 showed that the replacement costs per lawyer, these are hard costs, not indirect costs, are about anywhere from $200,000 to $500,000, depending on the market. It's about 1.5 times the lawyer's salary. And the replacement cost, including indirect costs, for a 100-lawyer firm is about $5.5 million annually, and $28 million for a 500-lawyer firm. Now, firms have been making some progress at the margins, but we're about 20 years behind corporate America in taking measures to improve mental health. And in other professions, they found that workplace interventions will lessen symptoms of depression and substance abuse. So for every dollar that a company spends on employee wellness programs, medical costs decrease by $3.27, absenteeism-related costs decrease by $2.73, and employers will realize $4 in increased employee productivity for every dollar spent. So it's in firms' interest to prioritize well-being as it will help improve firms' bottom lines through improved performance and help firms retain and recruit the best talents. So what does that mean? Well, first, performance. Employers who promote employee well-being and engagement have better business outcomes and employees who perform better. There are studies that show that mindfulness and happiness as a scientific measure can help yield better performance. Now, performance is critical as clients are demanding that firms move away from the billable hour model toward alternative fee arrangements. There was a school of thought that firms didn't need to worry about employee well-being because if they're billing by the hour and lawyers are inefficient, that's actually to the firm's benefit. But clients are demanding that firms move away from such a rigid method of billing and compensation. So in 2017, alternative fees accounted for about 20% of law firm revenues, but as much as 80 to 90% when combined with a reduced fee pricing. Nearly 68% of firms are working with clients to create some sort of alternative fee arrangements, and nearly 77% of large law firms are doing so. And large companies are demanding changes to their billing models. For instance, Microsoft and GlaxoSmithKline both require that outside legal counsel engage in some sort of alternative billing arrangement. And performance is also seen as critical as clients are demanding more value from outside counsel. A recent study demonstrated that corporate clients are at least seeking to cut about 82% of their legal spend. Second, retention, right? Companies that promote employee well-being have lower levels of turnover. The Association of Corporate Counsel have issued many statements over the years, recent years at least, showing that they see the imbalance or the importance of balance in the lives of their outside lawyers. Such that lawyer attrition and quality of life issues are considerations when choosing outside counsel, and that the quality of lawyer work, institutional knowledge, and continuity are important in maintaining relationships with corporate clients. And these larger benefits will create a better work environment and will rain down on everyone in the firm. And some companies are taking it even a step further now that the ABA has issued its well-being pledge. For example, 3M, itself a signatory to the ABA pledge, requires all of its outside firms submitting RFPs to answer not only whether they've signed the wellness pledge, but also to describe the specific steps that they have taken or plan to take to promote well-being among lawyers and staff at their firm. And finally, recruitment. The young millennials or older Generation Z lawyers and law students that are entering or about to enter the profession suffer from higher levels of mental distress than prior generations. Recent studies have shown that 56% more teens recently have suffered major depressive episode than those just 5 years before. And that current 20 to 21-year-olds are 78% more likely to have experienced serious psychological distress in the last month than a cohort about 10 years prior. And these students and lawyers are prioritizing well-being and balance, and they also see less of a stigma around talking about mental health and addiction issues. And this is seen in various avenues, most notably in athletics with Naomi Osaka and Simone Biles in connection with the 2021 Olympics. And this extends to lawyers and law students as well. So the 2019 American Lawyer Summer Associate Survey, so this was the last survey before the pandemic, found that work-life balance was the most important factor among these summer associates in considering whether to accept the job offer from their firm. And 42% of those respondents were concerned about their mental health because of, quote, the structure of the legal industry. And even younger students or younger folks are pushing towards and advocating for greater mental health and balance. In fact, the state of Virginia has removed questions from its bar application or character and fitness portion of its bar application related to mental health and addiction issues because of law student advocacy. Now, firms have definitely taken some steps in recent years to address lawyer well-being. Before the pandemic, firms have begun to acknowledge the issues and take action. There's a recognition that stress and workload of the firm environment is a principal cause of distress and substance abuse. The ABA pledge was issued in 2019, calling for all law firms to adopt and prioritize adopt the pledge and prioritize well-being. And as of January of this year, only 153 firms have adopted the pledge. Firms have begun to hire either as part of their human resources as staff members, or appoint people within their partnership to deal with issues related to employee well-being. And there have been focuses on providing resources, trainings, or other activities for lawyers and staff. And a second incremental step that has been taken relates to state bars. The Conference of Chief Justices resolved that questions regarding mental health and substance abuse be eliminated. And since that pronouncement, 5 states have removed such questions. Now, one of the things that I've been thinking about recently is how has the pandemic really impacted well-being, and not so much in a general sense of cause and effect, but more so whether and to what extent the pandemic is going to bring about meaningful change in the profession. So firms have taken some steps in light of the pandemic to promote well-being. Firms, at least one firm I'm aware of, credits up to 40 hours of what they call unplugged time towards their billable requirement, where lawyers are not required and encouraged not to do any work. Some firms are giving billable time credit for engaging in social justice efforts. Other firms have expanded childcare, work from home, obviously, providing concierge services at the firm, and so on, and providing check-ins and other types of informal get-togethers over Zoom. Now, this is all great, but at the same time, firms are using the pandemic as a way to maintain the status quo. And that's partly because revenues have increased in 2020, or they increased in 2020, in large part because of the amount of hours that people were able to work without pesky things like having a separate home life or commuting. But at the same time, junior and mid-level lawyers have been getting less meaningful work, less or no mentorship or training. And at the same time, they're working much more. There's an unofficial expectation at many AmLaw 100 firms, at least, that folks would bill about 3,000 hours. And there's a lot of uncertainty for incoming and junior associates. Many folks in the class of 2020 and 2021 have had delayed starts, have been furloughed, or their jobs eliminated. And now that firms are getting back to some version of normal with offices reopening, there is a growing sense of unease about what working from home could do for people's status within a firm, as well as their ability to advance. Now, I mentioned before that the ALM issued its 2021 Mental Health and Substance Abuse Survey, and they found that mental distress is the same, if not worse, than in pre-pandemic levels. So 37% report feeling depressed, 71% report feeling anxious, and 19% have contemplated suicide over the course of their legal career. And more than 3/4 believe that their work environment and the profession contribute to these issues. Now, many of the well-being initiatives that have taken place put the responsibility on the individual lawyers while ignoring the systemic issues within the profession that cause and exacerbate depression and addiction issues. So, having access to a meditation room or an on-site therapist or concierge services or yoga classes or gym memberships are all great and wonderful things that will help individual lawyers. But as one associate put it in a recent article, it's like putting a Band-Aid on a bullet wound. Unless and until we take care of the systemic issues that pervade the profession, will we only start to see change. And I posit that the responsibility should be on stakeholders beyond individual lawyers, because this really is a systemic problem rather than a problem of individual lawyers. And once those systems are addressed, I believe that the profession will be healthier, and more importantly, to law firms, more profitable in the long term. And I appreciate you all taking the time to listen, and I'm happy to take any questions if you have them.
Jared, thank you so much for your presentation, and I will be sure to drop your article in there as well in the chat. With I think what's really helpful is all the data that's out there, and I think Jared sort of just scratched the surface on the data now that's available. But I want to open it up now for comments, questions, discussion, anything related to Jared's presentation. Stop the recording too.